Hi, everyone. Welcome to this Fieldfisher webinar in which we'll be discussing the key data protection decisions of the Court of Justice of last year. I'm Tim van Canet. I'm the managing partner of Fieldfisher Belgium, and I'm joined by my brilliant tech and data colleagues, Nathalie Poupard, Ines Benazouz, and Naomi Capel. To start, I just would like to make a few housekeeping comments. We will, as always, be recording this webinar and subsequently post it on Fieldfisher's Data YouTube channel. And you will be able to find all kinds of other recordings of previous webinars that might be of interest. So just check it out. If you have questions, you will see the chat box, and feel free to type in the questions you have. We will address as many as we can at the end of the webinar. Before we start, let me just check. Before we start with the key, or what we consider to be the key decisions, we wanted to do a quick recap of the preliminary ruling process, and I appreciate or suppose that a lot of you will be by now be quite familiar with this, but we thought it was still useful to recap a few key principles. So first of all, it's important to bear in mind that claimants don't have a direct access to the Court of Justice in the context of preliminary rulings. The Court of Justice is always caught by a member state court. And so what it means is that this always starts with a procedure before a national court, in the context of which at some point there is a debate. How should we interpret EU rules? In this case, how should we interpret the GDPR? And if that is not clear to the parties to that case, but more importantly to the national judge, well, then that court may decide, and sometimes it's even required, to refer a request for interpretation to the Court of Justice of the EU. And so then the Court of Justice will analyze the questions in light of EU law and will give an interpretation of how a provision of EU law must be interpreted. So what that means is that the Court of Justice will never provide a final decision with regard to the actual dispute that was initiated before the national court. It will simply explain how the national court should apply EU law. That's why it's called a preliminary decision. So based on that decision, then the national court will have to subsequently adopt its decision on the merits of the case in line with the ruling of the Court of Justice. So it is, and that is important to bear in mind, that decision, the preliminary ruling, is binding upon the referring court, and this is really why the Court of Justice is so important in the context of interpretation of EU data protection law. The decision is also binding on all other national courts that at some point would have to deal with the same kind of problem in a local case. And so there is some sort of precedent value which makes that the Court of Justice really plays a crucial role in the context of the interpretation of GDPR and EU data protection law in general. Now, what I would add, and that's not on this slide, is that in the past year, especially what we have seen and what we're seeing more and more is other types of cases which are being dealt with at the EU level. And it's typically the appeal cases against the decision of an EU body. We will be discussing the Latombe case, of course, where the validity of the DPF adequacy decision was attacked. But we also see requests for compensation by individuals for damages that they claim they suffered following a breach of their rights by an EU body. And here as well, we have one example, which is the OC versus Commission case. These cases, and that's different from the preliminary rulings, they are initially brought before the General Court, and then there is an appeal possible against the decision of the General Court before the Court of Justice. So that was by way of quick reminder. Let's have a look, and those of you who have attended our webinars in the past on the CJEU decisions will know that we always put in some stats. So what we have seen if you look here on this slide, you see the referrals to the Court of Justice since 2018, since the GDPR became effective. And you see that in the early years, we really saw a significant hike in the number of data protection referrals, which then plateaued around 27 per year. Last year, there was a substantial drop. Not quite sure why that was the case. And then this year we again had 23 cases. I say this year, should be saying 2025. We had 23 cases that were referred, which is an increase, but lower than the peak years. And well, this is a little bit of speculation, but I think it suggests that national courts have become more familiar with GDPR, with EU data protection law, and therefore feel less the need to refer cases. Now, contrary to the number of referrals, the number of preliminary decisions continue to increase until last year. We saw a record of 28 decisions, but this year was remarkably quieter. Only 14 decisions in 2025, so just half of what we saw in 24. So much less activity by the Court of Justice on referrals, on preliminary rulings itself. And then I think another indication that data protection law has become mature is the fact that the grand chamber decisions have become the exception. If you look at the first years, it was either always a grand chamber decision, or it was sort of 50-50 between the grand chamber and the other chambers. Last year, 2025, only one decision was adopted by the grand chamber against 13 by the normal chambers. And as you may know, the grand chamber is that chamber which is composed of 15 judges, really a lot. And so it typically deals with the cases that are so-called of exceptional importance, which, if you then look at the drop of grand chamber decisions, might suggest that either the types of questions that are being referred are less complex, or they have less of a societal impact. Now, all of that obviously doesn't mean that the 13 decisions that weren't adopted by the grand chamber are irrelevant. I think it is still important for any data protection professional to continue to follow closely these decisions that are being adopted, because they remain essential to know how the GDPR and data protection law should be interpreted. And with that, I'll just quickly walk you through the decisions that we'll be covering in this session, and then hand over to the colleagues. We have 4 decisions which are mostly about Article 5 and all the data subject rights, so the data protection principles and data subject rights, Moose, Dun Bradstreet, the VP decision, and DDPS versus SRB. We have one referral question on non-material damages, which is the Kirin Bank case, but 2 others that we will be mentioning, which are before the General Court. There were, interestingly enough, 2 decisions that dealt with direct marketing, and then obviously this the Latombe case on transfers of personal data to the United States and the adequacy decision in that context. So that's what we have on the menu for you, and I will now hand over as we start with the first case, which is the Moose case.
Yes, thank you, Tim, for this very interesting intro. So this first decision, the Moose decision against CNIL, is dealing with data minimization, lawfulness of processing, and data relating to title and gender identity. So what is it about? Well, it's about an association which had sent a complaint to the CNIL regarding collection and recording of civility of the customers when purchasing train tickets. This association actually pointed out that the travel agency was asking the customer to indicate a gender identity limited to a binary choice between sir and madam when purchasing tickets, which would actually place the individual in a difficult situation that could be opposed with their personal feelings. So that's what the court is saying. And the CNIL had actually closed this claim and deemed it unfounded, and that was in 2021. Indeed, it considered that, as the law was, the use of common civilities, as I just mentioned, sir and madam, by SNCF Connect on its platform, did not constitute a breach of GDPR. So the association then decided to file an appeal for abuse of power against the CNIL decision and requested actually the transfer of those two questions to the court. So what were the questions? The first one was, does the mandatory collection of the title Sir and Madam comply with data minimization and lawfulness within GDPR? And can the lawfulness of this processing be assessed by taking into account the fact that the data subjects could then exercise their right to object? So those were the two questions. So if you look at the reasoning of the court, it's really interesting because the court is giving us a GDPR court, basically a GDPR lesson, and giving us in-depth information on the legal ground for processing personal data, and is actually confirming a lot of general data protection principle that we know. So first, the court is saying that Article 6 is providing an exhaustive and restrictive list of grounds for lawful processing. Processing is lawful if and to the extent that the data subject has consented for the specific purpose, and in the absence of consent, or if consent is not properly given, then the processing may be justified when it meets one of the conditions of necessity that you find mentioned in several points of Article 6. So the court reminds us that the ground on which processing without consent may be lawful must be interpreted restrictively. So that's the first point. When the processing is necessary for the performance of a contract, the requirement of necessity is not fulfilled, where the purpose could reasonably be achieved equally efficiently by other less intrusive means. So this is something that obviously most data protection experts already do. Regarding the legal ground, processing necessary for the performance of a contract, what is the court saying? Well, the court is saying that the collection of civility, and that's really what the decision is about, is not necessary for the performance of the rail transport service contract. So that's really important. For the performance of such a contract, so buying a ticket, only identification data, such as name or first name, for example, is considered necessary. So the treatment of civility, and by extension, the gender identity of the customer, is actually not an essential element for the performance of the contract. So here we are discussing a bit what is essential to a processing activity, and the court recalls that the latter must be objectively needed to achieve a purpose, which is an integral part of the contractual performance, and that's an important point. Therefore, the processing is considered essential if the main object of the contract could not be achieved in the absence of such a processing. So that's really an interesting point. The processing will be considered essential if the main object of the contract is not achieved in the absence of such a processing. Now, the decision is also discussing legitimate interest, and which is often used by controllers as a legal ground for processing. And the court is explaining to us again what are the conditions to have legitimate interest, but we already know that. And the court also indicates that commercial prospecting may require personalization of communication. This is also what the decision is about. Such an interest may be pursued by data controller. It's actually legitimate to decide to do this kind of personal communication. However, it considered that this interest may not be legitimate if the principle of data minimization is not respected. Thus, it considered that it is sufficient to process the surname and the first name of the person concerned to personalize a communication. It's not necessary to collect the title of the person concerned. And I think this makes full sense. And finally, the right to object, could it actually save the processing that is unlawful? Well, of course, the answer is no. So, in conclusion to this decision, well, I think it's an interesting and very practical decision from the court, which sends a strong signal on how strictly the principle of data minimization and lawfulness must be applied. In this case, the court held that requiring customers to indicate a title linked to gender identity is not necessary for the performance of a contract and cannot be justified under GDPR. So, and I think in a way the judgment goes beyond the specific context and it clearly limits data collection practice that are based on habits or convenience or marketing preferences. So let's switch to the next decision, Dun and Bradstreet. Ines, I give you the floor.
Yes, thank you, Natalie. We will now continue with the Dun and Bradstreet decision on automated decision-making. So in this case, a mobile telephone operator refused to conclude a contract with a customer on the ground that her credit score was insufficient. The contract would have involved a monthly payment of only 10 euros. Subsequently, the customer exercised her right of access under Article 15 of GDPR and requested meaningful information about the logic involved in the automated decision. Dun & Bradstreet, who's the company performing the credit score, declined to provide the relevant information, invoking trade secret protection. The referring court therefore asked the CJEU to clarify the interpretation of Article 15 in the context of automated decision-making, including its interaction with trade secrets. So the questions referred to the court were the following. So firstly, whether Article 15(1)h of the GDPR requires the controller to provide an exhaustive explanation of the method used to generate a result, such as credit profile. Secondly, how the concept of meaningful information under Article 15(1)h should be interpreted. Thirdly, to what extent trade secrets may limit disclosure under Article 15. And lastly, whether a controller invoking trade secrets to reject an access request altogether is required to submit the information to a court or to the supervisory authority so that a balancing of interests can be carried out. So moving on to the court's reasoning. Thank you. No, the slide before. Yes, thank you. So with respect to the interpretation of exhaustive explanation and meaningful information, the court held that the controller must provide information on all the relevant procedures and principles used in the automated decision-making. At the same time, that information must comply with Article 12 of the GDPR, meaning that it must be concise, transparent, and intelligible using plain and clear language. In practical terms, the data subject must be able to understand which personal data was taken into account and how this data influenced the outcome of the decision. Conversely, the court considered that the mere disclosure of a complex mathematical formula or the detailed description of all the steps in the automated decision-making do not constitute a sufficiently concise explanation to be provided to the data subject. The focus is therefore on ensuring that the data subject can understand the reasoning behind the credit score, rather than on disclosing the technical details of the scoring algorithm itself. Regarding the trade secrets and limitation to Article 15, the CJEU addressed the interaction between the right of access and protection of trade secrets. It recalled that the right of access is not absolute and that it must be balanced against other fundamental rights and interests, including the protection of third-party rights and trade secrets. However, any limitation to the right of access must remain necessary and proportionate. In other words, the controller must demonstrate that restricting disclosure is required to protect its interest and that the restriction must go no further than what is necessary. Lastly, regarding the balancing test, the court held that although the right of access is not absolute, the existence of trade secret cannot justify a general refusal to disclose any information to the data subject. And in this respect, where a controller considers that none of the requested information can be disclosed because it contains trade secrets, it must submit the information to the competent supervisory authority or to a national court. It is then for that authority or for the court to balance the rights and interests at stake and to determine the scope of the data subject's right of access under Article 15 of the GDPR. Now, moving on to the conclusions, the main takeaways from this decision is that a detailed explanation and meaningful information must be provided to individuals in a transparent and clear manner. This is to allow them to challenge the final outcome in accordance with Article 22.3 on automated decision-making. In addition, the controller must explain how the scoring works in a way that a non-expert can fully understand. And finally, a controller cannot rely on trade secrets to reject a right of access request. In such cases, it must submit the information to the competent court or to the supervisory authority, which will carry out the balancing of interests itself.
Thanks, Ines. Moving on to this next case, VP against a name I cannot pronounce. This case concerns the application of GDPR principle of accuracy and the right of rectification in relation to data on gender identity recorded in a public administrative register. So if you look at the context, so what happened in this case? Well, the case arose from a dispute in Hungary between an individual called VP and the Public Register for Immigration and Asylum. VP requested that the gender and first name in the asylum register would reflect the male identity. VP provided a medical certificate to confirm the trans identity, but the Hungarian authority actually refused, demanding proof of sex reassignment surgery. So this Hungarian authority actually was requesting a demonstration of this surgery. VP obviously challenged that refusal before the Hungarian court, and this led to a preliminary ruling at the Court of Justice. So the legal issue that were discussed here. The first one, does Article 16 of GDPR require an authority to rectify the gender in a public register if it's inaccurate? That's the first question. Then can we demand proof of inaccuracy of the data? And then can a state condition this rectification on a demonstration of sex reassignment surgery? So if we look at the reasoning of the court, let's break it down. First, regarding the principle of accuracy and the right to rectification. Well, this right of rectification, the court is reminding us that it's based on Article 8 of the Charter of Fundamental Rights and the principle of accuracy of GDPR. A piece of data must actually reflect the relevant reality with regard to the purpose of the register. So that makes sense. In this case, the purpose of the register is the identification of a person. This implies taking into account the gender identity experienced and not the one that was assigned at birth. So that's the first thing said in this decision. We should have a look at the actual gender identity experienced. A state may not invoke a legal vacuum or the absence of a national procedure to block this right. Only a legislative limitation in accordance with Article 23 of GDPR would be admissible. So now regarding the question of the evidence, because this was crucial in this decision, well, a person may be required to provide relevant and sufficient information, like for instance, a medical certificate, but it is not legitimate to require surgery. This would undermine dignity, physical integrity, and respect for privacy, and those principles are protected, obviously, by the Charter of Fundamental Rights. So such requirement as having to demonstrate that a surgery was undergone is considered disproportionate. In conclusion, this decision is giving us a clarification on the right to rectification. So the court is actually clarifying the scope of Article 16 of GDPR in the context of gender identity. Gender identity is recognized as personal data protected by GDPR. There is an end of disproportionate practices because clearly this was a disproportionate practices. And it's regarding the principle of proportionality, the evidence requested must respect the dignity and fundamental right of the person. This decision, I would say, will have an impact on public registries and the way that they are built so that they actually reflect the lived identity, even in the absence of a specific national legal framework. Now, moving on to the very famous Latombe case. Tim, I give you the floor.
Thank you, Natalie. So yeah, indeed, the Latombe case is well, actually, we had a couple of groundbreaking decisions. And we'll get to SRB a bit later, of course, but the Latombe one was definitely one of the most anticipated decisions because it was again about international data transfers and international data transfers to the US, I should add. So just by way of quick recap, what was this about? If we go back in time, obviously you will remember the whole safe harbor issue where the Schrems one decision decided that under the safe harbor framework, the adequacy, the essential equivalence was not assured, and so the Court of Justice struck down the safe harbor adequacy decision, which caused a lot of panic because from one moment to the other, all kinds of organizations relying on safe harbor had to recur to standard contractual clauses to continue to transfer data to the US. Then the Privacy Shield was intended to remedy the issues and the flaws of the safe harbor. And as you know, Schrems 2 then again, Court of Justice said, well, it's still not enough. And we really need to have essential equivalence. And this is why we are now all having to do transfer impact assessments whenever there is no adequacy decision. So that was Privacy Shield, got struck down, and obviously the EU and US administrations then started going back to the drawing board for the third time and came up with the data privacy framework. And so the Latombe case is all about that. And it's very different from the two Schrems cases because in Schrems, those annulations of the Privacy Shield and the Safe Harbor before were the result of preliminary ruling. So there was questions referred by national courts to the Court of Justice to assess the adequacy. Here, it's a very different procedure, and you can actually, for the nerds among you, you can see it if you look at the code of this decision. It starts with a T, not with a C. If you see decisions from the Court of Justice starting with a C, it means that it's a preliminary ruling. This one is a T decision before the General Court. And so it's Mr. Latombe, a French member of parliament, but also a commissioner at the French Data Protection Authority, the CNIL, who just in the days after the adoption by the Commission of the adequacy decision decided to file a request for annulation before the General Court. And so why was he doing that? A few technical, legal technical points, which I won't go into too much. One of the issues was that at that time, initially, the Commission only published it in English, the decision, not yet in all the other official languages. And he said that that was therefore unlawful and the decision had to be annulled. But more fundamentally, what he was claiming was that despite all the good efforts of the Commission and the US administration, under data that was being transferred under the data privacy framework was still not protected by an essentially equivalent level of protection. And effectively, what he was saying was that there were three issues. One was the absence of a so-called effective remedy for data subjects. So under the DPF and the adequacy decision, there is something called the Data Protection Review Court, which is a US impartial tribunal that is supposed to offer this remedy to EU citizens when their data is transferred and they want to contest potential access to their data. So the question was, is it really independent and impartial, and does it meet the requirements of Article 47 of the Charter of Fundamental Rights of the EU? First question. The second was still, as it has always been with transfers to the US, the question whether the DPF and the adequacy decision had sufficiently looked into the risk of mass surveillance, bulk interception of data by US intelligence agencies. And obviously there was an executive order that had been adopted to put some boundaries to that. The question was, is that sufficient, or can EU citizens or EU data that is being transferred to the US can it still be subject to bulk surveillance? And then finally, there were also some questions, again, linked to specific requirements around the security and whether or not there were potentially issues around automated decision-making and the security linked to that. So this was obviously a very mediatized case, a case where also the US administration sort of came to the rescue of the Commission in trying to convince the court that there was no issue and that the essential equivalence was reached and the adequacy decision could stand. Interestingly, the Irish government also intervened in this case and was also sort of pleading in favor of the Commission, but therefore also in favor of the US administration. And effectively on all these points, they were saying, there is no issue. And I would say, fortunately, the General Court followed the reasoning. Why I'm saying fortunately, because obviously for us data protection professionals, it meant that we didn't have to go back to our standard contractual clauses and go in another frenzy of repapering a lot of documents to cover the data transfers to the US. But so effectively, what the General Court decided was that the DPRC can be considered an independent and impartial tribunal, and that it does indeed, in the way in which the Commission had examined it, that the Commission could reasonably and lawfully conclude that the criteria of Article 47 of the Charter of Fundamental Rights were met. And the fact that that court had been set up by an executive order, which we know can be issued. I mean, someone even managed to issue 100 on his first day in office, so can be easily issued, but it can also be easily withdrawn. And that was one of the questions: is it too shaky a basis to be independent and impartial? And there, the General Court said that that is not the case. On the limitations to bulk interception and the question whether all of that is necessary and meets the proportionality test, there as well, the court did a very in-depth analysis to conclude that actually the Commission was lawfully concluding that there were sufficient limitations to the interception that could happen by US law enforcement agencies. And there was no need for an ex-ante judicial authorization. That is not what the Schrems II decision of the Court of Justice required. An ex-post independent, it has to be independent, of course, but an ex-post review may suffice. That was obviously an important one, actually to just draw a parallel, in many member states there is no need for an ex-ante authorization in every single case either. So this is really very much aligned with EU law or member state law, I would say. And then on the question of essentially equivalent, that was an interesting one, because there the General Court confirmed Schrems II by saying it doesn't have to be identical. So US law doesn't have to provide an identical level of protection. It having and offering an essentially equivalent level of protection is enough, and looking at what was on the table when the Commission adopted its decision, well, at that time the Commission could decide that that was enough. And then finally, all the points around automated decision making and security were also quite quickly dismissed. I would say there was less of debate around that, and the court simply said, "Yeah, the Commission, we cannot find any error in the analysis that the Commission has done on that end." So big relief, big sigh of relief when this decision was issued at the level of any organization transferring personal data to the US. As you can imagine, the DPF adequacy decision remains valid, and data can continue to flow freely to the US. You don't even need a transfer impact assessment, because here you are relying on an adequacy decision. What we have to acknowledge and bear in mind that is obviously this is the cat with 9 lives transfers to the US, so it's not the end of the story. It's, I would say, a pause. Mr. Latombe has filed an appeal against this decision, so the Court of Justice of the EU will need to reconsider the decision of the General Court. And we'll need to see how they will decide. So there's still a risk that the DPF be annulled. That is really unclear. And I think one of the elephants in the room, obviously, is the question as to how things will evolve in the US, how certain key principles of separation of powers and the rule of law will continue to survive or not. That's the big question mark. And those are certainly elements that might be taken into consideration by the Court of Justice to assess whether the adequacy decision can be maintained. So yeah, certainly a very important case to continue to watch and keep on the radar. It will take a while. We don't necessarily expect already the decision in 2026. It's always hard to tell. But if I would have to put some money on it, I don't like to gamble, but I would rather expect this decision somewhere in the course of 27. So that was Latombe, and handing over then to
me.
to you, Natalie. Yeah, I'm sorry, I didn't remember, but to you about
Yes.
the real landmark decision, I would say, of last year, the SRB case.
Yes, so that's the decision we were all waiting for, and it actually was adopted the following day of Latombe. So that was really a productive period of time. So this decision SRB is really interesting regarding the concept of personal data and pseudonymized data. So what is it about? What this decision arises from the resolution of Banco Popular Español by the Single Resolution Board. As part of the compensation procedure for shareholders and creditors, the SRB was collecting personal data from participants, including identity details and information on ownership of financial instruments, and written comments as well. Those comments were forwarded to Deloitte for analysis. Deloitte was an independent expert working on this, and the data were pseudonymized before sent to Deloitte. In this case, the data subject had not been explicitly informed of this transfer to Deloitte in the privacy notice. So several complaints were brought before the EDPS, which found that the SRB had breached its information obligation under the regulation applicable. So indeed, transparency should have applied. It didn't, and that's what it was about initially. But this case raised a number of important legal questions. First, whether pseudonymized comments can still qualify as personal data, and more broadly, whether pseudonymized data are always personal data. Second, how the concept of identifiability should be assessed in practice, and particularly in this context where there are several actors involved and an external third party. And third, whether the obligation to inform data subject must be assessed from the perspective of the controller, in this case it's SRB, or from the perspective of the recipient, Deloitte. So let's have a look at the reasoning of the court. So the court starts from a very broad interpretation of personal data under EU law. It confirms that personal data is not limited to factual or identifying information, but it can also include opinion and assessment, provided that they relate to a person by their content, purpose, or effect. So on this basis, the commented submitted by individual in the context of the resolution, they actually reflected personal opinion and views. And for this reason, they were considered personal data at the level of the controller, so SRB. Then the court discussed this very interesting topic of pseudonymization. The court makes it clear that pseudonymization is not a new, or pseudonymized data is not a new category of data. It's more automatic. It's more a process that automatically removes data from the scope of data protection law. So pseudonymized data remain personal data as long as the risk of re-identification has not been eliminated. That said, pseudonymized data may be considered anonymous from the perspective of a specific recipient, provided that this recipient has no realistic mean of re-identifying the individual. And that's really the interesting part of this decision. So this leads the court approach to identifiability. Identifiability must be assessed from the perspective of the recipient of the data. And that's what the court is emphasizing in this case. In this case, the court accepted that for Deloitte, the pseudonymized comment did not constitute personal data because of the technical and organizational measures that would prevent Deloitte from re-identifying the authors. And so that's really interesting. This conclusion is nevertheless subject to strict condition. First, Deloitte must not be able to waive the safeguard put in place. Second, those safeguards must effectively prevent any attribution of comment to individual, including through other means. If those conditions are not met, then in that case, the data would remain personal data even for the recipient. In the reasoning, the court was also discussing transparency obligation because the data subject had not been properly informed. If the data is not personal to the recipient, then the recipient is not obliged to inform the data subject. On the other hand, the data controller, so in this case it's SRB, the data controller must inform the data subject of the sharing of their data with third parties. So in conclusion, this decision is clarifying the concept of pseudonymized data, and this is exactly what we were waiting for a very long time. Pseudonymized data can actually be considered anonymous from the perspective of the recipient, but don't forget that there are conditions and that we must make sure that this recipient cannot re-identify the data. This decision is also clarifying the concept of transparency. So who should inform the data subject? But of course, there are some remaining questions, specifically on the contractual arrangement, and also a lot of questions on how to perform this re-identification risk assessment and how to perform the documentation in this new context. So at this point, we are still waiting for EDPB to adopt guidelines on this and to confirm all this because this is against the DPA's usual interpretation of the concept of personal data. So interesting time to come, I would say. Okay, so moving on to this decision also coming on the 4th of September. So as I said, it was a productive time. It's IP versus Query. Ines, I give to you.
Yes, thank you, Natalie. We will now move on to the IP versus Quirin private bank case concerning non-material damage under Article 82. So in this case, a non-authorized disclosure of personal data occurred during a recruitment process at Quirin Private Bank, an employee of the bank mistakenly shared an applicant's salary expectation with a third party who was not involved in the recruitment process. That third party knew the applicant and subsequently reached out to him, asking whether he was seeking employment. The applicant brought proceedings before the national court, and he saw first an order requiring the bank to cease any further unlawful disclosure of his personal data, and second, compensation for the non-material damage he claimed to have suffered as a result of the incident. He argued that the disclosure exposed him to reputational harm and competitive disadvantage since the third party was in his professional sector and could circulate his confidential salary information. So the questions referred to the court were the following. Firstly, does the GDPR grant a data subject whose data have been unlawfully disclosed and who did not request erasure of their data the right to obtain a prohibitory injunction as a preventive measure? Second, what constitutes non-material damage under Article 82.1 of the GDPR when the data subject relies on negative feelings? And lastly, must the seriousness of the controller's fault influence the assessment for the compensation for non-material damage under Article 82? So on the court's reasoning, next slide, please. Thank you. Regarding the prohibitive injunction as a preventive measure, the court held that the GDPR itself does not provide such a preventive judicial remedy, nor Article 17 nor Article 18 grant a standalone right to obtain an order requiring the controller to refrain from future unlawful processing. That being said, the court also considered that the GDPR does not prevent member states from providing such a remedy under national law. So in other words, and in practice, the GDPR does not establish such right, but it does not prevent member states from introducing it under national law. Regarding the threshold for non-material damage under Article 82, so the referring court essentially asks whether negative feelings such as fear, annoyance, worry, resulting from an unlawful disclosure of personal data can qualify as non-material damage. In this case, the applicant claimed that he experienced fear that his data might be circulated within his professional sector, annoyance about the potential misuse of this data, and concern linked to the disclosure of his salary negotiations. The court reaffirmed its previous case law and adopted a broad interpretation of non-material damage. In this respect, it held that the fear of future misuse of personal data may in itself constitute non-material damage, provided that the data subject demonstrates that those feelings and those negative consequences actually happened and were experienced. The assessment of this remains for the national court, of course. The CJEU therefore confirmed that negative emotions such as fear or annoyance arising from a loss of control over personal data can fall within Article 82. Lastly, regarding the non-relevance of the controller's degree of fault, the court also clarified how compensation under Article 82 should be assessed. It held that the seriousness of the controller's fault cannot be taken into account when determining the amount of damages. Since Article 82 is fault-based, the controller is liable unless it proves that it is not responsible for the event giving rise to the damage. However, once liability is established, compensation serves as a purely compensatory function. In other words, the assessment focuses on the damage suffered by the data subject and not on the seriousness of the controller's conduct. The court further ruled that the fact that the data subject has obtained a prohibitory injunction does not and cannot reduce the amount of the financial compensation. So as a conclusion, the main key takeaways from this decision is that the GDPR itself does not create a right to a prohibitory injunction for data subject, but member states can provide such a remedy under the local laws. Negative feelings such as fear and annoyance can constitute material damage. provided that they are demonstrated by the data subject. And lastly, the seriousness of the controller's fault cannot be used to reduce or assess compensation. I will now hand over to Naomi.
Thank you, Ines. So I will conclude this webinar by referring to two decisions that were brought before the courts by Romanian courts, actually. So the first case concerns Intelego Media, which is a Romanian online legal news platforms, and it addressed the lawfulness of direct marketing by email, and more specifically, the scope of the so-called soft opt-in exception. So just a quick reminder, in principle, marketing emails require prior consent. The e-privacy directive allows an exception where the email address was obtained in the context of a sale or a service. The marketing communication concerns the sender's own similar service or goods. The individual was also properly informed and given the opportunity to object, and each email includes an unsubscribe option. So what's the context here? So in this case, we talk about a platform that provides online legal news, and Intelego Media enables visitors to read up to 6 articles per month for free without creating an account. If they want more content, then they could create a free account, so-called a premium service, by providing an email address. Once they are registered, they have access to 2 additional articles per month, and by default, they also receive a daily email newsletter unless they decide to opt out. For an additional fee, the user can subscribe to full access to the platform and receive premium newsletter. So the Romanian DPA here found that the newsletter constituted direct marketing and has been sent without valid consent, which Intelego Media disagreed with. And against that background, there is a broader question that is raised, which has never been really clearly settled before, whether access offered for free, such as limited free access or free trial models, can still qualify as sale for the purpose of the soft opt-in. So the ECG was therefore asked 3 questions. So the first one was whether this type of newsletters or legal information qualifies as direct marketing. The second question was whether an email address collected through a free account can still be regarded as collected in the context of a sale. And finally, the final question was whether when the soft opt-in applies, whether there is a need for a separate legal basis under Article 6 of the GDPR. So on the first question, next slide, please. On the first question, is this type of newsletter direct marketing? The court takes quite a broad approach to the concept of direct marketing communication. Indeed, according to the court, even though the newsletter contains only legal updates, the court really focused on its purpose and effect. In practice here, the email really encouraged the user to consume their free article quota and nudge them towards upgrading to a paid subscription. That commercial intent for the court was sufficient. The court considered and confirmed that the informational content does not fall outside e-privacy directive simply because it's not overt advertising to the extent that it promotes the provider's paid offering and it is sent directly to the user. On the second question, the court gives a broad interpretation to the concept of a sale under the e-privacy directive. While a sale normally entails payment in exchange for a product or a service, the court makes clear that a direct monetary payment by the user is not required here. It is sufficient that the free subscription forms part of a broader commercial strategy aimed at converting user to a paid service, and that the cost of the free offer are economically incorporated into the price of the paid subscription. On the final question, so when soft opt-in applies, whether there is a need for a legal basis under the GDPR, the court confirms that the e-privacy directive, it has a lex specialis effect, where the e-privacy directive lays down specific conditions for lawful processing. Those rules are exhaustive. And that is quite surprising because this means that the e-privacy directive itself provides a sufficient legal basis for sending marketing email, and there is no need to rely on additional legal basis under the GDPR. So in other words, here there is no need for legitimate interest, which is surprising because this is not the position that was taken by most data protection authorities until now. So what can we conclude from this decision? Well, this decision really confirms that soft opt-in may extend to newsletter linked to free or freemium access model, even when there is no monetary payment that is made, provided that the offering form part of a broader commercial strategy or a value chain. The court also noted that a soft opt-in was an exception to the general consent rule, and so it has to be really narrowly construed. In other words, we can consider that time-limited free subscription are likely covered by that exception, whereas genuinely free offer without a paid version at the end are likely not to be considered and will require consent. Business that wish to rely on the soft opt-in must still ensure that the marketing concerns similar products or services offered by that provider, and they need to provide a free opt-out both at the time of the collection of the data and in every message. Looking ahead, there is still another open question. It is whether the lex specialist approach confirmed by the court also applies in situations where prior consent is required. If the court were to take that view, then the e-privacy directive will fully govern this area. So in other words, you would only need consent for direct marketing, but you wouldn't need that consent to generally meet the criteria under the DPR, which will significantly reduce the compliance burden as the rules under the GDPR are much stricter. But for now, this point remains open, but this is definitely something to watch closely in future case law. So now let's move on to the other Romanian case, which will also close this session, which is Rus Media Digital SRL and Inform Media Press SRL, which concerns the scope of the hosting liability exemption under the e-commerce directive, now reflected in the Digital Services Act, or DSA, and more specifically, when an ad contains personal data. So just a quick reminder, in essence, the exemption of the hosting liability exemption it's an exemption that provides a safe harbor for hosting provider in respect of illegal third-party content uploaded on their hosting platform. And there are some conditions, including the fact that they don't know the content was uploaded, and also the fact that once they are notified that there is illegal content on the platform, they take measures quite promptly to take it down. So here the case, we have a Rus Media, which is a Romanian operator of an online marketplace where user can publish ads, either for free or for a fee. And here we have an anonymous user who posted a fake ad portraying a woman as offering sexual services. And the ad included two things. So first, her photograph, which was used without her consent, and also a telephone number. So the woman notified Rus Media immediately, and within 1 hour, the ad was taken down from Rus Media, but unfortunately, it was already republished on a third-party website where it remained accessible. So the woman who is also the claimant brought the proceeding before the Romanian courts and alleged violation of her image right, reputation, and data protection rights. And in the national courts, they really disagreed on whether Rus Media could rely on the hosting liability exemption under the e-commerce directive, or whether it could instead be held liable under the GDPR. So the questions that were referred to the court were the following. The first one is, under what condition an online marketplace can be regarded alongside the user who posted the content as a controller or joint controller of personal data contained in user-generated content. The second one is, what preventive check and measures such a platform must implement before publishing advertisement that may contain personal data, and what step it must take to limit further the dissemination of unlawful content once published. And the third one is really on the interplay between the e-commerce directive and the GDPR. It's whether a provider that has infringed the GDPR can nonetheless rely on the hosting liability exemption under the e-commerce directive. So moving on to the analysis of the court. I don't think we have the right slide here. My
Yeah.
apologies for
I don't know
this.
what happened, Naomi. I will let you find the slide because I
Yes,
didn't do anything. So,
here we are.
okay.
Thank you, Natalia. So turning to the court's reasoning, so the first issue that the court dealt with was controllership. So here the court held that Rus Media acts as a controller because it makes ads publicly accessible and determines how, where, and for how long they are displayed. This follows in particular from the platform design and also its T's and C's that were quite detailed actually. Although here the user really determines the content of the advertisement, the platform co-determines the purpose and the means of the publication. And on that basis, the court considered that Rus Media was regarded as a joint controller with the user for the publication of the ad on its own website. Then the court looked also at what were the verification and the measures that need to be implemented by the platform for controlling whether personal data were uploaded within the ads. And here the court said that in this case specifically, the risks are particularly high because there are sensitive data which are published by third party, which on top of that can be posted anonymously. And in such case, it's important for provider to implement appropriate technical and organizational measure to ensure that the publication is lawful. In practice, this includes identifying advertisement containing sensitive data before they are published. And to do so, provider must also verify the identity of the user posting the ad to determine whether it relates to that user. If it relates to that user, then the court considers that the posting may amount to consent. It really depends on the situation. And if the posting does not relate to the user that published the ad, then the provider must check whether the user can demonstrate that the data subject on the ad has given his consent for the publication. If consent cannot be demonstrated, then the ad must be refused. In addition to that, the court says that providers must also adopt appropriate security measures in order to reduce the risk that the ads are being disseminated and copied on other websites, which was the case here. And then finally, on this case, the court also examined the question of the interplay, as I mentioned, and the court held that where a provider qualified as a controller in respect of publication of personal data, it cannot rely on the hosting liability exemption to avoid responsibility for GDPR non-compliance. So to conclude, what should we remember from this case? So Rus Media confirms here that where a platform qualify as a controller or as a joint controller for the publication of personal data, it must comply with the GDPR, and it cannot rely on intermediary liability protection to avoid that responsibility. At the same time, when the court analyzed the controllership, it reminded us that controllership is fact specific, and here it's really like some elements really came into play, such as the platform design, the T's and C's, and how the user-generated content is used. And these were factors that were taken into consideration. So it's really a case-by-case analysis. Finally, there are also some issue with this decision because it leaves some practical uncertainties, such as when it comes to the measures that are required by the courts, so the preventive and also the security measures, the courts give limited guidance on the concrete implementation for online marketplace. And so there are still some questions with respect to the level of identity verification or with respect to the security measures that would be considered as appropriate for the court. Finally, there is also the preventive approach that is suggested by the court, which in some situation resemble to pre-screening of content, which creates potential tension with the prohibition of general monitoring under the Digital Services Act, which is the successor of the e-commerce directive. And on that point, the court does not fully resolve this tension. So this closes our session on the main decision of the Court of Justice of 2025, and we'll be happy to respond to any question you may have in the Q&A. Thank you.
Yes, thank you, Naomi. And there were a few questions that I've answered directly in the chat. I'm conscious that we're slightly over time, so unless there is any sort of final burning question, please type them now. Otherwise, we will wrap it up. But I think in any event, as you will have seen, we again in 2025 have seen several decisions which have really shaped and specifically speak about SRB have changed the data protection landscape quite substantially. We have no doubt that the Court of Justice will continue to do that in 2026 as well. The Fieldfisher Tech Data team is obviously continuously monitoring everything that is happening there, and we will keep you posted if there's any groundbreaking or super important decision or referral that is coming our way. I don't see any other questions coming in, so I will thank you all for your presence. I hope you thought it was interesting, and hopefully see you at our next webinar. Thank you.
Thank you.
Thank
Goodbye.
you.